doctor. My name is Koh Yuen Han and my metric number is 274056. The part that I'm going to present is Introduction. Based on the scenario given, the parties whose rights have been infringed are the residents of Troy Village and Hazim. The rights of the residents of Troy Village are being infringed as they are dissatisfied with Shifa's actions of flowing 2 models of drones. Ka Yao has to take actions against Shifa, who refused to stop her actions of collecting drones. On the other hand, Hazim also needs legal help as his rights to see the view of the Botanical Green Park directly was blocked by the building built by KFA Sindra Berhad. Thus, we'll discuss these two issues further and provide relevant and comprehensive legal advice to both parties. Issue 1. Whether Ka Yao can seek a prohibitory injunction against Shifa with the help of the prohibitory injunction may prohibit Shifa from continuing his disturbing action. That is all for issue 1. I will now pass the floor to the next presenter.
Assalamualaikum and good day to madam. My name is Nur Fitrah Azaman and my magic number is 272633. Now I'll be explaining about the law or principle in the first issue of the case. So the main principle in this case is injunction. Now what is an injunction? An injunction is an order by the court to compel someone or to refrain them from doing something, and if the defendant fails to follow this order, it would result in him committing a contempt of court. It is provided under Part 3 of Specific Relief Act 1950, which provides provisions for preventive relief, which is also known as injunction. There are a few types of injunctions which are divided into purpose and time injunction. Purpose injunctions are prohibitory and mandatory injunctions, while time injunctions are consisting of perpetual and temporary or interlocutory injunctions. Now, let me first explain about perpetual injunction because this has relevance in the issue that we're discussing right now. So, according to Section 51(2) of SRA, perpetual injunction is an injunction granted by the court only after the court has heard the arguments from both parties and after the parties have fully established their rights. And it is also mentioned that once the court has granted this injunction, the party would permanently be prohibited from asserting a certain rights or doing something which would breach the rights of the plaintiff. Besides that, Section 53(3)(a) until E provided circumstances where the court would grant perpetual injunction to the plaintiff. These circumstances include when the plaintiff's rights or enjoyment is breached with the defendant, and the defendant is a trustee of the property that on behalf of the plaintiff, when there is no standard to ascertain the damage caused by the invasion, when pecuniary compensation would not be enough for the plaintiff, when it is not possible for pecuniary compensation to be acquired for the invasion, and to avoid the multiplicity of judicial proceedings. Next, I'll be explaining about temporary and prohibitory injunctions. So, Section 51(1) states that unlike perpetual injunctions, temporary injunction is granted before both parties' rights have been established and before the trial of the full merits of the case. And you can apply this injunction at any time of the suit. This means that this injunction is not a permanent one and could be changed somewhere in the future. Finally, perpetual injunction is an injunction granted by the court to restrain someone from doing something that would be detrimental to the plaintiff. So if a plaintiff does not want the defendant to do something, he can refrain these actions by applying for prohibitory injunction.
Good day, madam. I'm Loh Chia En with metric number 272921. Now I'm going to talk about reference to some decided cases. Speaking on interlocutory injunction, we shall refer to the decided case of Ahab bin Uda and others versus Syarikat Pelombongan Gua Musang Sendran Berhad and others. The plaintiffs sought an injunction to stop defendants from conducting a number of activities including trespassing and conducting commercial activities within the vicinity of the customary land. The court took in the principles outlined in the case of American Cyanamide Company versus Ethicon Limited, where the court must be satisfied that there is a serious question to be tried in granting an interlocutory injunction. Most importantly, the interlocutory injunction does not decide the rights of the involved parties, but to maintain the status quo of the matter until the rights can be decided by court. On the other hand, from a recent decided case, Chayon Land and another versus Kamaruzzaman bin Maidin and another, the plaintiffs are residents in the area of the defendant's premise, which is used as a Chinese temple. The function of the temple has caused inconvenience to the residents in such area, including the plaintiffs. The High Court had highlighted that in this case, there is no standard to ascertain the actual disturbance caused, and pecuniary compensation would not afford adequate relief to the plaintiffs. Besides, the court has also mentioned that Section 51 subsection 2 provides that a perpetual injunction can only be granted by the decree made at the hearing. And finally, the High Court decided to uphold the decision of Sessions Court to grant the perpetual injunction to the first defendant, who is the proprietor of the premise, to restrain him from using the premise as a Chinese temple. That's all from me. I shall pass the floor to the next person. Thank you.
Thank you, my teammate, for passing the microphone to me. I am Amelie Gan Zhi Ying, metric number 272767. Now, I will start to present about the application part of this assignment to you guys. We will advise Karma to seek prohibitory injunction against Shifa in court. This is because the action of the Shifa, which have flown 2 models of drone above the roof of his neighbor and landed in the botanical green park, might infringe the right of airspace of the neighbor and already provoke the dissatisfaction of the neighbors. Prohibitory injunction can restrain the commission or the continuance of his wrongful act. If the court decide the drone already invade the height necessary for the ordinary use and enjoyment of the neighbor's land, the prohibitory injunction will be granted by court to stop the wrongful act of Shifa. Prohibitory injunction can be interlocutory and perpetual. We will advise Karma seek for prohibitory interlocutory injunction first. This is because an interlocutory injunction is granted to keep the status quo between the parties until the final hearing of the action or the termination of the dispute. In the case of American Ceramic Company versus Ethical Limited Company, the House of Lords state that the plaintiff need not to prove a prima facie case, as the court will determine whether there is a serious question to be tried, such as the claim is not frivolous. If there is, and there is a doubt on adequacy of damages, then the court will consider whether, based on the balance of the convenience, an interlocutory injunction should be granted or not. In addition to that, there may be special factors to be taken into the consideration in the particular circumstances of individual cases. Only at the hearing and upon the merit of the suit, a perpetual injunction can be granted. If the court decides that the action of Shifa already invade the neighbor's right, a perpetual injunction may be granted to prevent the breach of an obligation existing in favor of the Karma. Shifa will thereby perpetually enjoy from the accession of a right which will be contrary to right of Karma and neighbors. That's all from me. I will pass the floor to the next presenter.
In conclusion, Ka Yao can seek for a prohibitory injunction against Shifa, as Shifa actions has infringed the legal right of the residents of Tri Village. Ka Yao applies for a prohibitory interlocutory injunction before the hearing so that the status quo between the parties can be kept until the final hearing of the dispute has been done. After the hearing, the court may grant a prohibitory perpetual injunction to Shifa, because perpetual injunction will only be issued by the decree made at the hearing and upon the merit of the suit, in accordance with Section 52 of Special Relief Act 1963. That is all for Issue 1. Thank you. Issue 2. Whether Hazim can apply for a mandatory injunction against KFA Sdn Bhd. This is because Hazim, who is a 10 years resident in the Tri Village, previously owned the right to see the view of the Botanical Green Park directly, but his right has been infringed by the building built by the KFA Sdn Bhd. That is all for Issue 2. I will now pass the floor to the next presenter.
Assalamualaikum and a very good day I bid to madam and also fellow friends. My name is Nadia Syuhada binti Rosli, metric number 273118. Today I'll be explaining about the principle of law used in the second issue, which is injunction. Injunction can be defined as an order of the court to a person to do or not to do a particular act, and it usually can be either prohibitory or mandatory injunction. However, in this video, I'll be only explaining about a mandatory injunction as we have a very limited time. In Malaysia, the provisions that aim to deal with mandatory injunction is laid down in Specific Relief Act, particularly Section 53. This section explains that the court has a discretionary power to grant an injunction to any party of the contract, and it includes the power to compel a person to perform some necessary acts. Additionally, it's very important for us to read the section together with the illustration. Illustration A of the Section 53 explains that when a person wants to build a building on his land, he must not obstruct the rights to use and access of the other owner who has acquired it through specific convenience. The same principle applied to right to view as mentioned under Section 44 of the National Land Code. According to that section, a landowner has a paramount right only to the airspace above and on the ground below the land. And that's all from me. Thank you.
A very good day, I bid to Madam Rules and my fellow friends. My name is Ka Yao, metric number 272807. Today, I will present the decided cases for issue 2. There are 2 cases to be applied. First, it is the latest decided case on Community Private Limited and Cat Tat Hua, Senyang Berhad and others. In this case, the defendant asked the plaintiff to sign the discharge form over the property. However, the plaintiff refused to sign because the defendant was still in debt to him. The issue that arose in this case is whether the plaintiff is entitled to apply for a mandatory injunction to prohibit the discharge and ask the defendant to produce the original document for inspection. The court did not grant the mandatory injunction because the plaintiff's pleadings are devoid of any discernible cause of action. Hence, the reasoning is that the application of mandatory injunction was completely misplaced and was without any legal basis. In other words, without fulfillment of the element and cause of action, there is no right to obtain a mandatory injunction. The second decided case is Dennis and others and Davis, which has a similar fact to the situation given. In this case, the plaintiff applied for a mandatory injunction to prevent the extension of the building on the defendant's property. This is because the extension would constitute a nuisance and obstruct the attractive view of the river Thames, which they currently enjoy. Therefore, the issue is whether the claimant is entitled to a mandatory injunction due to the right of view to the river. The court held that no mandatory injunction is allowed. The reasoning of the judgment is the court will infer from the specific circumstances on the cause of action, the grave suffering on the claimant, or the incident that may become an annoyance, nuisance, or disturbance to the neighborhood. If the mandatory injunction is easily applied, it will unreasonably restrict the freedom to construct a building on his land and obstruct good development. So that's all from me. I'll pass the floor to the next presenter. Thank you.
Then, Madam, I'm Hui Hong with matrix number 273410. Now, I would like to continue our group presentations regarding the applications of the case. Through our best effort in researching and analysis, we found that there are a few common points between the decided case and the current circumstances faced by Hazim, which amongst them the most significant similarity is regarding the legal right in applying for mandatory injunction. There are 3 necessary requirements in proving the existence of such legal rights on behalf of the plaintiff, which are the balance of hardships in the sequence of common law relief in compensating the loss suffered, and strong possibility in suffering grave damage in the future. Firstly, in terms of the first requirement of balance of hardship, the ground that was put before the court by Hazim is supporting his mandatory injunction claim is in relation with his interest regarding the view of Botanical Green Park from his house. However, KFA Senyang Berhad, on the other hand, may be suffering a more serious undue financial hardship in the case when a mandatory injunction is ordered against them, as they will need to remove or lower down the new building that have just completely be done. Hence, it is not an exaggeration to say that the balance of hardship tips strongly in favor of the defendant. Moving on to the second element of inadequacy of common law relief in compensating the loss suffered. In general, the owner of the property is lack of legal rights to an unobstructed view, and thus the interference of the view by KFA Senyang Berhad new building is not unlawful. Hence, Hazim could suffer no damage and it is likely for him to fear in constructing an actionable nuisance. Even if Hazim is in fact suffer loss caused by the obstruction of view, such damage could be rectified by a monetary payment. Last but not least, in respect of a strong possibility in suffering grave damage in the future, since Hazim is not entitled with any recognizable legal rights to an unobstructed view, there is no grave damage which should be suffered by him merely on the ground that interference of view by the new building. As for the public interest, it is the responsibility on behalf of Hazim in proving by evidence that the possible damage suffered by the public must not be too speculative, remote, and insubstantial. Since Hazim failed in proving all the 3 elements in establishing the existence of a legal rights, there is absence of legal basis on behalf of him in raising the claim for mandatory injunction.
In conclusion, Hazim cannot apply for a mandatory injunction against KFA Sendirian Berhad as he did not fulfill the elements of mandatory injunction. The first reason is Hazim cannot prove the balance of hardship lies on him. Next, Hazim failed to prove the inadequate damages to the losses suffered. The last reason is Hazim would not suffer a serious damage, albeit the court refused to grant a mandatory injunction. Thus, no mandatory injunction can be applied to Hazim. That is the end of our group presentation. Thank you.